Creating a last will and testament in Louisiana without seeking legal advice may seem intimidating. However, drafting an official will can be rather simple and straightforward, and it can usually be done without an expensive attorney. In this video, we'll go over the importance of wills and what happens when one isn't made, what's included in wills, legal requirements in Louisiana, and how and where to create an official will. Let's begin. Wills and their importance. A last will and testament, also simply known as a will, is a document that allows an individual to set written instructions on how their assets are to be distributed after their death among family, friends, and other beneficiaries. It is recommended that all adults have a will in place, particularly those who are elderly or suffering from a life-threatening condition. Now, what occurs if no will is left? A person who passes away without a will loses full control of who inherits their property. Instead, Louisiana law dictates how the deceased property is handled and dispersed. The assets are usually passed by default to the deceased spouse or children, but it varies from case to case. Disputes between loved ones can unfortunately arise when beneficiaries are determined by state law and not the person to whom the property belongs. Therefore, one can avoid ambiguity by making a clear will document and opt in without an expensive attorney required. A person of sound mind can draft a written will in Louisiana that includes the following information: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property and what each shall receive, any additional terms and conditions, the signature of the testator, and 2 witness signatures, and a notary acknowledgement. Let's conclude by reviewing 2 key legal requirements in Louisiana. In order to be legally enacted, wills in Louisiana must be signed by the person to whom the will belongs, known as the testator, in the presence of 2 competent witnesses and a notary public. And each page of the will must be signed by the testator. For instance, if the will has 5 pages, then the testator must sign all 5 pages. A signed will can be registered with Louisiana's Secretary of State office in order to safekeep the document, and the testator can distribute copies to other trusted individuals. We're eForms, the biggest database of legal documents. We have created last will and testament templates specifically designed for Louisiana that are quick and easy to fill out. Our software generates an official document right after you select your desired will instructions and name all of your beneficiaries. Click on the link below to begin creating your will. And don't forget to like and subscribe for more daily videos.